A recent video was done regarding what probable cause is, what the loophole is regarding reasonable suspicion, the way they have to articulate it, and the principles behind it. Some of you liked it, some of you didn't. The law doesn't care about how you feel. But this is what happens when you know the principles behind the video regarding the reasonable suspicion and probable cause and the loopholes behind it. When you become one with those principles within that video, this is the result that it gets you. Here's a transcript from a supposed criminal case. You're wondering, do these things work? If so, where's the evidence? Well, here's another one. The Circuit Court of Cook County, Illinois, County Department, Criminal Division. Let's do the important part. So, you say motions don't work. Don't file motions. All right, that's fine. You don't file motions. You keep doing all that stuff you're doing. See where it takes you. Although it might make you feel good that you're saying something, but focus on the end goal, which is to acquit you of the claims. If you cannot accomplish that battle in a victorious manner, then you're wasting your time. You don't want to do that. Have fun, but make sure you fight that battle with the sole intent of victory, not just wasting resource to fight the battle, not just for the purpose of saying, hey, I did that battle, or to just tell a story in the future to say, oh yeah, I said that, and then he said this, and then I said that. But how did it end? Did you lose something valuable to you? Did they kick your ass? You want to be able to talk a bunch of trash about what you said and what they said, and then at the end of the day, say, yeah, I won that battle. That's how it ought to be. So if you don't use motion to dismiss, good for you. But this is what motion to dismiss gets for you. This is what motions get for you, if you know what motions are and how to use them. This comes here for a ruling. This was an argument on a motion to dismiss. They will use the verbiage argument even though none of that really took place. The defendant is charged with obstructing identification and resisting peace officer. As to the obstruction identification charge, the defendant obstructed identification by refusing to give his name or date of birth when asked by the officers. This is not obstruction of identification. They're telling you your mere refusal to give ID is not an obstruction of identification. This is an official court transcript. The statute clearly states a person commits obstruction of identification when they intentionally furnish a false name, residence, date of birth to a police officer who was lawfully arrested or detained that person. This count must be dismissed. The four corners of the complaint do not state an offense under Illinois law. This, line 21, 22, and 23, is your slam dunk when you do a counterclaim or when you sue them. Take this transcript of this case being dismissed and sue them. Why? Because it shows on the face, based on what another magistrate or acting judge is saying, that look, this guy being arrested was unlawful. Why? Because it says nothing regarding Illinois law, meaning they were not acting in an authorized manner. Illinois law being the Constitution and the common laws, aka compiled statutes, which are basically just an inferior version of the General Assembly version, which is the General Law Public Act. As to the resisting peace officer, it states defendant may not only resist the performance of an officer of an authorized act within his official capacity, being the arrest of the officer to be in execution of his official duties, that he refused to get in the back of the blah 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 blah, all that crap. So they're letting you know that they were not engaging in their official act or an authorized act, since the language of the law does not support their contentions. So you cannot resist an arrest if there was no charge to begin with. The charge was supposed to be obstruction of identification. As a result of that, the cop was saying, well, when I attempted to arrest him for obstruction of identification, he resisted. So I'm charging him with resisting arrest, which they will do also. They love doing that. But the initial supposition of obstruction of identification is not based on any Illinois law. You merely saying you're not going to give an ID does not invoke any laws that you're breaking. And because of that, the resisting arrest was dead also. It is not sufficient, according, and this is the State General Assembly Law, 725 ILCS 50141, which states it is not sufficient that an information really set forth the name of the offense and cites the statute which defines the offense, meaning merely citing the statute against you, or you citing any law against anyone when you sue them, is not enough to state a claim. Merely saying that this man or woman broke this law is not enough. The charging instrument must give notice to the elements of the charge and particularizing it with allegation of the essential facts to enable the accused to prepare a defense which, if successful, would bar further prosecution for the same offense. Meaning you have to have preponderance of evidence. Simple as that. And the charging instrument being the complaint. Keeping ourselves within the four corners of the complaint, meaning whenever any ruling is done in any court, the complaint is the main thing that they will use. Whatever you put on your complaint. So don't just look at what they're doing now. Look at it from the perspective of what you'll be doing now when you sue them. What you put in your complaint is what you're going to ride all the way home. What every other motions and every other move you make after that is going to be relying on that. It's like a house. You need a foundation. The foundation for your suit is your complaint. Everything else that they're going to attack is going to be your complaint. Everything else that you're going to say to support it so that you could go home with a check in your pocket is your complaint. So your entry game, your complaint must be strong. And they're telling you, keeping ourselves within the four corners of the complaint. They're telling you the complaint itself is what we're looking at if you bring it any claim. And they're letting you know merely citing a code is not sufficient to state a claim upon which relief can be granted. That's what this is. It is not sufficient that an information release set forth the name of the offense and cites the statute which defines the offense. It's not sufficient. Keeping ourselves within the four corners of the complaint, which is what I can consider in a motion to dismiss. A person has a right to know what they are being arrested for. The resisting count must be dismissed. It is not particular as to what authorized act the officer was performing or what official capacity the officer was acting. Meaning even the trial court was telling you, look, this man was acting in his personal capacity. This is your pass. This is your green light right here. This transcript is your pass and your green light to use when you sue him to show this is why I'm suing him in his personal capacity. This is why you can garnish his check. This is why I can put a lien on his property. This is why I can take his 401k. This is why I can take his lockbox. This is why I can do a garnishment, a lien and levy to his bank account. This is it right here. This official self-authenticating transcript right here. You want to sue someone, you have to play your cards right. And this is how you begin to do it. No facts alleging what the defendant was arrested for. And within the motion to dismiss statute, therefore, it does not give the defendant the opportunity to prepare a defense. Both counts are dismissed. Does that terminate proceedings? Nothing else from the state, Your Honor. Pardon me, nothing else from the state, Your Honor. And that was it. Case dismissed. What's next? Go make some money. There's a right way to do things, and there are wrong ways to do things. I mean, how much better can it get? You're holding them liable, and you're making money doing it. How much better does it get than that? This is not even something that they can appeal, because it is succinct and clear that it violates the Fourth Amendment, the United States Constitution. They cannot appeal this. This is a case that you can use in any other state based on full faith and credit. If you're in Illinois, even better. Best of luck.